Let us begin this Constitution Day event with a moment of silence for Ruth Bader Ginsburg, a renowned jurist who fought to uphold our constitutional rights. Good evening, and welcome to So Important and Interest, Slavery and the United States Constitution. I'm Deirdre Jones, and I want to welcome you to our final event for our Constitution Weekend. You may know me as a programming lead for the Actor-Interpreters and maybe recognize me from my time around Colonial Williamsburg, portraying free and enslaved Black people. But this evening, I have the pleasure of serving as your moderator. I am also joined by Allie Orr Larson and Hope Wright. Hope Wright, my dear colleague, began her career at Colonial Williamsburg when she was in the 3rd grade. She was a performer in a play, On My Own Time, and the Black Music Program. She has collaborated with many other departments at the Foundation, as well as with other museums over the course of her career. She has worked with a variety of educational institutions as an actress, storyteller, writer, researcher, and mentor. Please welcome Hope Wright.
Thank you.
Our special guest, Allie Larson, is a professor of law and director of the Institute of Bill of Rights Law. Since she joined the William & Mary faculty in 2010, she has received many awards, including the statewide Outstanding Faculty Award in the Rising Star category. Professor Larson is a scholar of constitutional law and legal institutions with a focus on how information dynamics affect both. Her work has been featured multiple times in various publications, and these are just a few of her accomplishments. Please help me in welcoming Allie Larson. Our discussion, it will be about an hour long this evening, and it may feel uncomfortable at times. That's okay. You may feel angry. That's okay. You may feel sad. That is also okay. All of these feelings arose for me when I was researching for our event, and it is okay to feel something. This reminds us that we care. Now, while slavery is not the beginning of the story, for the purposes of trying to dive into two very large topics in a very little bit of time, we'll start our evening with meeting Lydia, a woman from the time period who we find in her home speaking with Elizabeth de Rosario. Allie, did you know that Hope has portrayed Elizabeth de Rosario? Hope, why don't you introduce briefly Elizabeth?
All right, Elizabeth de Rosario is a free Black woman who lived in Williamsburg, a mother of 2 daughters, Caroline and Suki, and also a property owner. So someone who did quite well for herself as a free Black woman in Williamsburg.
Thank you so much, Hope.
You're welcome.
Now, Lydia, she was legally enslaved to George Wythe, one of the delegates who attended the Constitutional Convention. Now, this is behind us, and in this interpretation, it is September 19th, 1787. We find Lydia in her home sharing some important news with Elizabeth.
It says, "Be it known unto all men by these presents that I, George Wythe of Williamsburg, do emancipate and set free my Negro woman slave Lydia, given under my hand and seal this 20th day of August in the year of our Lord, 1787. Good day. I am Lydia, and I am a free woman. Oh, Elizabeth, I don't know where my emotions will go this week. My mood is a pendulum swinging between elation and despair. I have yearned for freedom ever since I knew I was a slave. As you well know, Elizabeth, the paths to freedom for one born a slave is very, very difficult, almost impossible. When Eve and Agnes and Lucy told me of their plan to join the British during the war, I thought on running too. Then I thought better of it. What was I going to do at a British war camp? I shudder to think what they have endured. What has become of all of the people who sought their freedom by aligning themselves with the so-called enemies of their so-called masters? No, I thought, this is not my path. Benjamin agreed, and so we waited. We waited for Mr. With's words and deeds to align. Eloquent talk of these gentlemen about the rights of man is enough to make anyone hopeful. And I was hopeful when the Declaration of Independence said all men are created equal. But nothing changed for us. And as the war started raging, my thoughts turned to our survival. Freedom lingering in the back of my mind as we lived through the devastation that war brings. Freedom in the back of my mind when I learned of the law that was passed in 1782 about the manumission of slaves, allowing the manumission of slaves. Surely, I thought, now is the time. Mr. With will free us. He must free us. And so we waited. Another 5 years, Elizabeth. And for what? For the death of my mistress? I will never know what Mr. and Mrs. With discussed in private. Was it her dying wish to see us free? Or was it her living wish that kept us enslaved? Am I glad to be free of her? Interesting choice of words, Elizabeth. It is complicated. I do mourn my mistress. It is hard to believe that she is gone. She and I developed a way of being with one another throughout the years. I ingratiated myself to her. For us, this is a matter of survival. I helped her manage her household with the utmost skill and cleverness. And in return, she allowed me a few comforts in this life. And for that, I am grateful. However, a mistress is a mistress. Ugh, you remember when I begged her to let me travel with her as her maidservant? Yes, 11 years ago when they traveled to Philadelphia in '76. Yes, you do. When they traveled to Philadelphia for the Convention on the Declaration of Independence. I wanted to go. I wanted to go so badly. Of course, Benjamin was driving them, and he would be gone for as long as they were. And I so wanted to immerse myself in the free black population of Philadelphia. The free blacks outnumber the slaves there. In Paris was so young. I'm sure that Fanny would have preferred to stay here and care for her child. But mistress reminded me of my place. You are housekeeper, Lydia. Your job is to tend to the house. What need is there for you to travel? Fanny is my maidservant. She will travel, and you will stay here. And that is that. This beautiful home has been my prison. Oh, when Benjamin returned from Philadelphia, the stories he had about his encounters with the free blacks there. How we dreamed of freedom then. whispered about what we would do with it, plotted how we might get it. And now we are free. And Polly will be free when she matures, and Charles is free. But Kate, Rachel, Lydia, Lucy, Bob, Jamie, Fanny, Paris, Isaac, Rose, and Edward, they will not be free. Mr. Witt is giving them to the Tollivers as a gift. They are to be divvied up amongst my dead mistress's nephews and nieces. And it makes me want to cry or scream or punch something. How can I celebrate my freedom, Benjamin's freedom, when so many that I love are still slaves?
Lydia was grappling with her newfound freedom, but she has been enslaved for most of her life. Now, as it relates to Lydia and this time period, what is the definition of slavery? How would you define a slave?
Well, an enslaved person is somebody who is bound by slave laws, and I think that's important to point out that slavery is entrenched in the laws here in Virginia and all colonies. It's far and wide reaching. It changes people's classifications. It puts limits on what they can and cannot do. And it's not just one law or a handful of laws. It's hundreds of laws that are amended and strengthened over time.
Well, can you speak a little bit about the laws that codified slavery here in Virginia or anywhere?
All right. Well, before we talk about the laws, there are a couple of cases that kind of set precedent. One is in 1640, and it involves 3 men who were in servitude. One was an African man by the name of John Punch. The other 2 were men of European descent, Victor, a Dutchman, and James Gregory, a Scotchman. So they were all in servitude. They ran from Virginia to Maryland, were caught and returned to Virginia. So they all committed the same crime. You know, they were runaways. They were all caught together. They did the same thing. But you begin to see racial differences in treatment here with this case, where Victor and James Gregory were made to serve their original owner 1 additional year in the colony of Virginia for 3 years. John Punch was made to serve his owner and his owner's assigns, or his heirs, for the rest of his natural life, wherever they lived.
And John Punch was black.
John Punch was black. He's referenced as African. In this record. But then you also have another case that turns out a little different in 1656, where you have a woman by the name of Elizabeth Key. And Elizabeth Key had a mother who was of African descent and a father named Thomas Key, who was of English descent and rather prominent. And in English law, traditionally, everything goes through the father. And she had been baptized as a Christian. So there were, there were restrictions on how Christians could be held in bondage, the type of bondage they could be held in. And Thomas Key made arrangements for his daughter that after he died, if she was under the age of 18, she serve in this family and then be considered free at the age of 18. However, a great bit of time had passed since her 18th birthday. She was into her 20s, and she sued for her freedom on the fact that it had been a breach of contract, but also 2 very important points is that she had been baptized as a Christian and her father was a free Englishman. And we see a different outcome with this case, where Elizabeth Key was found to be a free woman, and she was also paid in bushels of corn, I believe, barrels of corn, for the additional time served in which she should have been free. So these are 2 legal cases that show different precedent. And when the first law is passed, you can actually tell that it's a little reactionary, because the first slave law in Virginia, when it's passed in 1662, it says, whereas there have been questions as to the status of children born, of an African woman and a white father, this law in 1662 states that the status of the child is that of the mother bond or free.
Which is something different than what you usually see in English common law?
Yes, everything goes through the father. things are bestowed, the first son inherits the most, has rights, titles, what have you, so on and so forth. So this is something very different. And this is something that will be very important as we do get a little bit closer to the Constitution. You have set into motion a system of servitude that's perpetual and that's hereditary. So by the time you get to the 1780s, most people who are large slave owners, they have gained those enslaved people through natural increase, through inheritance, through wives' dowries. So they're, not to say that people aren't still purchasing slaves, that is something that is still very much going on. But when you think of people who own hundreds of enslaved people, if you look at somebody who owns 200, it's very likely that they didn't purchase 200. They might have purchased a dozen or so. But when you look at that property and assess a value to that property, oftentimes when you look at inventories of the period, most of the value of the things that people own when they pass away is going to be vested in enslaved. So just that law alone has, provided a system in which wealth is built just through the natural increase. Yeah. That's just one.
Yes. And so do you find other laws? Are there other laws that are codified in this time period that sort of solidify or start to solidify the institution of slavery?
Yes. With Elizabeth Key's case, one of her points was also that she had been baptized as a Christian. So in 1667, we see a law passed that says baptism does not alter a person's status, bond or free. Because in addition to Elizabeth Key, there were other people. And that is something that should be pointed out, that Black people were still very active in trying to use the legal system at this time. And actually not just the 17th, but even into the 18th century. But now this law in 1667 is closing another window. And you still continue to see enslaved people being baptized at the Bruton Parish closest to us in Williamsburg and in other parish records. But oftentimes, this usually becomes a way to keep track of the birth of an enslaved person, because now taxes are being paid on enslaved people when they become 16, which kind of leads to another law, and more than just one law. The classification of enslaved people from the very beginning has always been that of property, and not as people, where if you are indentured or if you are an apprentice, you have certain rights by virtue of being recognized as human in the eyes of the law. But from the very beginning, enslaved people are never recognized as human beings.
Thank you for that.
You're very welcome.
When you consider, you had mentioned, she had mentioned inventories, taking note of people, and baptismal registries as places where enslaved people show up. And I think when researching enslaved people, those are places that I know that I have used, and that you because Hope has taught me to use them. So can we also get into Lydia? She receives her freedom in that interpretation that you all saw. What were some pathways to freedom for enslaved people, especially once those laws started coming down in the 1660s? Do you know of any enslaved people that received their freedom?
Well, you see, before kind of like the big revision in looking at slave laws, also known as the Black Codes, oftentimes it's individuals. It's one individual who petitions the court or petitions the governor's council. But when the Black Codes are kind of solidified in 1723, you see a law pass that states that for an enslaved person to be granted manumission, they would have to perform some type of meritorious service or deed. And even then, the only group of people that could confer the status of freedom, could grant that manumission, would be the governor's council. So we know that there were probably about 50 or 60 or so of those petitions that go before the governor's council, and they're approved at about 2/3 or so. But that's still a very small number of people who gain their freedom that way.
And that's just looking at Virginia.
That's just looking at Virginia.
Wow. Now, Virginia in the 18th century was a very agrarian society. and cash crops of the 18th century, such as tobacco, indigo, sugar, rice. They lead us to believe, or they lead us to believe, that slavery was only in the South. Now, will you all be able to speak a little bit on the regional differences over slavery heading into the Constitution?
Well, it's by and large, there are two definitions. A slave society is basically, I think it's like where over half the population is enslaved, and that is mostly the South, where it is
Slave society.
Tobacco, slave society, tobacco, indigo, and rice that you mentioned. But the North is still very much a society with slaves, where you have people working in homes a little bit more, in taverns, skilled trades. Not that didn't happen in the South as well, but by and large, the whole economy is based on the agriculture there. So there is never an absence of slavery ever in any of the 13 original colonies. And actually, the same time the John Punch case is going on in Virginia, Massachusetts is the first colony to legalize slavery of the original 13.
Thank you.
You're welcome.
Did you want to add anything?
I was just going to say that the early colonies, slavery was pretty much equivalent, like the rate of slavery was equivalent in the North and the South. By the time we get to 1787, there are pretty stark regional differences. There's a lot more enslaved people in the South than in the North, for the reasons Hope suggests, with the difference in the economies and the agriculture and the longer growing season, and this sort of thought that you need to have more slave labor in order to take advantage of that growing season. So that sets up some pretty fierce battle lines when we get to the convention in 1787.
Well, let's go there. Let's jump right into 1787 and that time period. About how many delegates to the Constitutional Convention owned slaves?
So there's 55 delegates to the Constitutional Convention, and we've all heard the stories. It's a hot summer in Philadelphia, and they've taped up the windows. And of those 55 people, 25 of them owned slaves. So that's almost half. But I think it's important to recognize that even the delegates who didn't own slaves, there was not a lot of talk of racial equality. I mean, it's not a racial paradise, even in the states where slavery is slowly being phased out. There's still a consensus, as you were talking about before, that enslaved people were property, and there's a lot of talk about property rights and the property rights of the people that own the slaves. And that's shared among all of the delegates in the Constitution. Even the anti-slavery voices would stop short of saying that a national government could divest a person of their property rights.
Wow. And is that something that you all want to share? You mentioned that slavery was starting to be phased out. So like we're post-revolution, we are several years removed from it. Are there states that are trying to do away with slavery?
Pennsylvania's the first, right? So the Quakers were the first, and then there were like gradual emancipation schemes where you might not confer someone's freedom right away, but when they reach a certain age, then they are given their freedom. So this is starting to happen in some colonies by the time we get to the Constitutional Convention, but it's not the norm.
I think that Virginia even makes a law that makes it easier for masters to manumit their enslaved people after or towards the end of the American Revolution. So now that we're in 1787, we're thinking back on it. What were they trying to do? What is the Constitution? What were they trying to create? Why create a Constitution?
Yeah, what's the fuss about? So the Constitution is the paramount law in the United States, which means it trumps all conflicting laws. And it also means it's really hard to amend. So I think of the Constitution in part as a mission statement. So it embodies values that we share as Americans and we strive for. Another really important part of the Constitution, though, was to set up the national government. So it's a long story, but the short version is that the government they were existing under, the Articles of Confederation, was failing. Congress did not have enough power. They couldn't regulate commerce. They couldn't tax. Instead, they had to ask the states for money. And it was operating more like a League of Nations of 13 different countries as opposed to one United States of America.
So. Is that sort of how the Articles of Confederation were used?
So the Articles of Confederation required unanimity in order to change anything. You're never going to get that. Rhode Island was always a stinker. They always held out.
Love you, Rhode Island.
Love you, Rhode Island. But so it's just a very different change from we, the 13 sovereign states, all of whom have our own rules, to we, the people. That was a huge change to have popular sovereignty. And so a big function of the Constitutional Convention was creating and instilling the national government that we now know.
Wow. We, the people. So knowing that we alluded to how slavery denied the humanity of people, where in the Constitution is slavery mentioned? Is it mentioned? Do they say anything about slaves?
Yeah. So it's an interesting omission. The word slavery is never used in the Constitution. They use euphemisms like other persons. And I think that omission is telling. I think it shows that even if they weren't willing to abolish slavery in 1787, there were plenty of them that were uneasy with it. Madison wrote to Jefferson and said it was going to be the Achilles heel of the country. So I think that omission is telling. Even though they don't mention slavery by name, though, there are 3 explicit provisions in the Constitution that protect slave owners, that protect slavery. The first one is probably the one that everybody is most familiar with, and that is the 3/5 clause. So you all remember that the way our Congress is set up, there's 2 chambers. There's a Senate and a House of Representatives. And reaching that was the great compromise, right? To make sure that the small states and the big states, everybody was happy because the Senate, all the states got 2 senators.
Everybody.
Right. Not everybody. Every state. Yeah, good clarification. But the House of Representatives is apportioned by population. So this is the big fight, is about power. And the southern states would like to count slaves towards their numbers so that they have more representatives in Congress. And the northern states do not want that. And so it's a fight over who has more representatives in Congress. But I want to be clear, it's not a fight about morality. It's a fight about power. So even the northern delegates, they're arguing, that slaves are property. It's really pretty ugly. And the southerners who are saying we want to count them as whole people, they're not doing it because they're treating them like whole people. They're doing that because they want more representatives in Congress.
Right. It seems like we see that throughout the 18th century of enslaved people being used to the advantage for slave owners to gain power. Is the 3/5 compromise? Well, I think you touched on this a little bit. The 3/5 compromise seems like it's directly related to the Great Compromise because it was all about the numbers of people and trying to get more power. Neil Nielsen was wondering, were northern or southern states more responsible for the horrific 3/5 rule? What was the motivation? Well, we talked about that a little bit, but does 3/5 show up anywhere else in leading up to this point in 1787?
So they would have been familiar with the fraction because Madison had used it in a proposed amendment to the Articles when dealing with taxes. So he had used 3/5 of a person in order to count for purposes of taxation under the article. So that's where it comes from. But in terms of who's to blame, I think there's enough blame to go around. So it was seen as sort of a very important stepping stone to actually reaching a constitution, to reaching a document that would tie all 13 colonies together. And without it, the consensus was that we wouldn't have a constitution. Wow. Because those 5 southern states, they were ready to walk, right?
Do you think that they really would have done it? I don't know. We'll
knows?
never know.
Yeah.
We'll never know
Who
now.
knows? But that's what they said.
Wow. So you had mentioned that there were three sections that directly related to slavery. What is the second one?
The second
clause?
one has to do with the importation of enslaved people. So this is the foreign slave trade. And this was really controversial in the convention because under the Articles of Confederation, the earlier government, Congress did not have power to regulate the slave trade, and the southern states wanted it to stay that way. the northern delegates were much more willing to fight the slave trade than they were to fight domestic slavery. I think part of that is because of the property rights that we were talking about before. There's no vested property rights when you're talking about the importation of new people. I think part of it is also just politics. So the upper South of Virginia was actually making a fair bit of money selling slaves to the deep South. And it's to their economic advantage to stop the competition from the foreign slave trade. Right, that's pretty grim, right?
Yeah.
Well, I know that I've heard Hope tell me before that Virginia was started very much to make money, and I imagine that it was the same for all the other colonies, and that probably didn't change when they became states, especially after the war. So what
happened?
Yeah.
Yeah, so this is actually a quid pro quo. So in exchange for extending the slave trade till 1808, so in the Constitution, Congress is not allowed to stop the slave trade till 1808, and even then it's an option. But in exchange for that, Congress gets the Commerce Clause, which turns out to be a really important source of power for the national government. The southern states didn't want Congress to have a Commerce Clause without a supermajority, and they gave in on that as long as they got to protect their foreign slave trade for 20 years. By the way, Jefferson did eliminate the slave trade in 1808 as soon as the Constitution allowed him to do it. And this was one of two provisions in the Constitution that was not amendable. That's how much the fight was so vicious that once they reached that compromise, it was not amendable.
Well, that's fascinating too, because it links in, it seems like, with what Hope was talking about natural increase almost perpetuating itself, which probably was happening at greater rates in Virginia than in some of those more southern states, that people had a lot less of a life expectancy growing things like rice and indigo. Thank you. Now, you said there was one more.
Three, yeah.
There was the third one.
Presidents always do that.
Sorry,
They say there's three, and then they give you two, or they give you four.
No, please do.
No, the third one is the fugitive slave clause, and this is the clause that gives Southern slave owners a right to have their enslaved people returned to them if they escape to the North. Here's the interesting thing about this. By the time we get to the Civil War, this is a huge controversy. It's a huge divide between the North and the South, because the Northerners really hated having to return formerly enslaved people who had run away back to their owners in the South. They hated that. But at the time of the convention in 1787, this was not controversial at all. It was introduced at the end of the convention by a South Carolina delegate. There was no quid pro quo. There was no compromise. It was just, there was no debate. There was no objection. It was just another example of how, even if there were anti-slavery voices at the convention, and there were, Ben Franklin, Alexander Hamilton, those voices stopped short of thinking that you could divest a property owner of their property. Just not how we think. I mean, it's really jarring today to think of it that way.
But I imagine too, like in that time period, from the 1600s, from the from the 17th century, they have been practicing this mindset of denying the humanity of enslaved people. And so, if it comes down to their property, or what they believe to be their property, or the humanity of people that they're telling themselves aren't human, it still doesn't make sense to me. It still doesn't make sense to me. But I'm a 21st century kind of woman. I cut you off again. I'm sorry. Did you want to add?
So there's an obvious tension between the all men are created equal rhetoric of the Declaration of Independence and treating humans as property. I mean, that's an obvious tension, and I don't want it to come across like they didn't recognize that.
Right.
Like, there were plenty of people that recognized that tension. Abigail Adams recognized that tension in a letter. But it was just a non-starter, I guess, to think in 1787, this practice that had become so ingrained that they were going to come out with a constitution that abolished it.
Thank you so much. We have a question from Nan Sizzler Schools. They want to know what was the total number of representatives and what percentage insisted on keeping slavery. Can you speak a little bit about that?
Sure. So there's 5 of the 13 colonies are in the South, and they are not going to ratify an anti-slavery constitution, and everyone knows that. There were 25 of those men, as I said, like over almost 50% of those men actually owned slaves. And even the ones that didn't were not pushing for racial equality. So it's a very different world than the world that we know. It's sometimes hard to put yourself back in that perspective. But yeah, there were 5 states that would not have signed a constitution that gave Congress the power to abolish slavery.
Wow.
That's why we had a civil war.
Yeah, it seems like that was became inevitable, just delayed. And it's interesting. Before you had mentioned about, oh, it's gone now, about the choosing to see them as property and not as people, and about how that's how they saw them. But even in like Gazette ads that we've read and that we've considered, you see the social recognition of their humanity in some cases, referencing people who have gone to look for their wives or gone to look for their husbands, even though legally enslaved people couldn't marry. And so it seems like again, whenever it's in the favor of the delegates, that they choose whatever's best for them, which is human, right? They were people, just like the enslaved people were. So you mentioned a little bit about the compromise, but if you want to add a little bit more on how compromise or how you all see compromise affecting our Constitution, and how it affected people of the time. Do you have any examples or?
Well, how about I start and then you can come up with the people of the time. But one thing to think about is, I mean, you can think of the Constitution in 2 ways. So they were writing a political document, a document that was a political compromise, which meant there would be concessions and not everybody's going to be happy. In the ratification debates, actually, the Northerners think it's actually put slavery on the road to extinction and that's a reason to sign it. And the Southerners think, no, it's protecting slave interests and that's a reason to sign it. So in some ways, that's an example of an effective compromise if the 2 sides are taking what they want to see. But another way to look at the Constitution is as a statement of values. And if you look at it that way, they didn't want to write the word slavery in it. They were uneasy about slavery, even if they were protecting it as a political document. There were several delegates to the convention that very much hoped slavery was on its way out. That doesn't, let's not throw them a parade, right? That doesn't mean it's cause to celebrate. But I do think you can look at it as they didn't want to taint the document that they were hoping to endure for generations with the horrors of slavery.
It was aspirational, hopeful. Thank you. Did you want to add anything?
I think when you think of compromise, it was these 55 men in a room that were making the compromises with each other, but it was at the expense of so many, and especially of enslaved individuals, where decisions were being made about them, and if they weren't even at a table and in a position to have a say-so in that. And that's also something you see, like once a law is written, we see how just the definition of property was written into the law and how it still had all these effects 100+ years later, that when compromises have to be made, it's at the expense of oftentimes, free and enslaved Black people.
Thank you.
Who don't have a voice.
Yeah.
Right. And we often at work get these questions about, well, what about women? And this is to not be confused with women, because women come in all shades, colors, and complexions. And so again, we're focusing primarily on women of African descent. And even though women weren't at the table, they did have rights. White women did have rights, unlike Black women of the time period. Thank you.
And that
yes.
comes back to the first question you asked Hope, which is, what is slavery? I mean, it's legalized ownership of another human being, buying and selling and abusing and having the legal right to do that.
Right.
that makes it in a totally different category than anyone else who was not in that room.
Thank you. I think you said that perfectly. Thank you
And,
so
and
much.
when you
Yeah.
mention, when you mention just, runaway as it lists, gone to his wife, even though it wasn't something that was legally recognized, just what being defined as property, just that classification alone cuts you off from so many things, from being legally married to someone, from, as a parent, especially a mother, as an enslaved woman, before you even bring children into this world, any children that you do bring forth, they will automatically belong to the person that owns you. So just that classification alone, it reverberates through history. And what it means to you, and what you're restricted from, the benefits and privileges and rights that you don't get because you're not seen as human.
Thank you.
You're welcome.
We continue to deal with the effects of choices made in the past. Now, according to Gary Nash in his book, The Forgotten Fifth, the argument that slavery could not have been abolished reeks of the dangerous, indeed odious, concept of historical inevitability. Almost always in historical writings, a concept advanced by those eager to excuse mistakes and virtually never by those writing on behalf of victims of those mistakes. The idea of historical inevitability is a winner's weapon as old as the tales told by ancient conquerors. I think you touched on this a little bit earlier, but I'm going to go ahead and ask. Was abolishing slavery ever something that they intended with the Constitution?
I mean, the difficult answer is no.
The honest answer.
Yeah, I mean, it's a difficult answer, but it's no. I mean, there's a lot of truth in that statement, and I don't mean to excuse the men in that room that made the decisions they did, but according to the debate records, it was a non-starter. I mean, it wasn't even something that Alexander Hamilton or Ben Franklin thought they were authorized to bring to the convention, even if they were willing to fight for it in their own states. This is something I should have mentioned. Not just the property rights idea was entrenched, but the idea of state sovereignty was so entrenched that it wouldn't be a national solution to this problem, that it would be individual states with the authority to decide when slavery was abolished, if slavery was abolished. So even the anti-slavery voices were not going to push for a national government with power to abolish slavery.
Wow, thank you. Now, we know, as you mentioned, that about 25 of those 55 delegates that were in the room, they did own enslaved people. Slavery was still present in the United States. And even today, with researching this topic, looking back over 200 years, trying to find information about not only the debates, but the people that those gentlemen owned. I've been hitting a lot of walls, but right now, you are going to see an interpretation that takes place in Philadelphia in 1787.
Do you remember me? No. Well, perhaps you know my master. He met here at Independence Hall with about 55 other gentlemen. For months, day after day, they met here in Philadelphia to debate the ins and outs of the new Constitution. And now, those debates and discussions have ceased. For the moment. One of the men would go on to be remembered by some as the father of the country, and my master will be known as the father of the Constitution. Can you imagine him sitting there with his quill flying across the paper? He did his best to take notes of the discourse of the convention, secret notes, which were not to be released until the members had died. But did he write down everything? He wrote that Gouverneur Morris of Pennsylvania protested that slavery is a nefarious institution. It is the curse of heaven on the states where it prevailed. He noted that Charles Pinckney of South Carolina said that if slavery be wrong, it is justified by its example to all the world. He even wrote the words of John Rutledge, a man of that same state, South Carolina. He said that if the convention thinks that North Carolina, South Carolina, and Georgia would ever agree to the plan, unless their right to slavery, to import slaves, be untouched, the expectation is in vain. The people of those states would never be such fools as to give up so important an interest. So important an interest. Yet, my master and the other gentlemen were very careful not to mention this interest by name. None of our names. He saw fit to write the discourse and debates as they drafted this new Constitution, but did not mention whether or not I was in the room. He did not mention if I opened the windows, lit the candles, offered refreshments, or stood there, ignored. Ignored as I've always been, unless, of course, something goes wrong. Then I am the first to be accused. Yet, thanks to history and those that chose to write me out of it, you don't even know my name.
James Madison owned Sarah, William, Sookie, just to name a few people. George Washington owned Abram, Adam, Alice, and Anthony, and the list goes on. George Mason owned Samson, Nance, Bridget. Charles Pinckney of South Carolina owned John, Helena, Peter, Molly, Hester, and many others. These are just a few names that we can remember today. George Washington knew that the subject of slavery was unavoidable by the time of the Constitution's ratification. And by that time, the institution was already thoroughly mixed into the foundation of our new nation. So, skipping ahead in time a little bit from 1787 and 1788, what happened to the Constitution after the Civil War?
So the Constitution was radically changed after the Civil War. So there's 3 amendments that were ratified in the wake of the Civil War, and we call them the Civil War Amendments or the Reconstruction Amendments. It's the 13th Amendment, which abolished slavery in 1865. The 14th Amendment, which is the one we probably know the best. It was in 1868, and it attached a bunch of civil rights to all people, but particularly for formerly enslaved people. So this is where you find the guarantee of equal protection under the law and the guarantee of life, liberty, and property without due process of law. You can't be deprived of it. That comes from the 14th Amendment. And then the 15th Amendment, which was in 1870, the 15th Amendment guarantees the right to vote regardless of race, not gender, not sex, but race. So cumulatively, these 3 amendments just completely changed the relationship between the states and the federal governments. So before the Civil War, the idea was that the states would protect your rights from this big, bad, distant national federal government. After the Civil War, it's the federal government that is given the power to enforce these protections against the states. So it's the 14th Amendment, for example, that is used to dismantle Jim Crow laws when we get to the civil rights movement in the 50s and 60s. It's the 14th Amendment that is the source of authority for Brown versus Board of Education in 1954.
Before we get too far there, I want to go back to the 13th Amendment a little bit. It abolishes slavery, but if I recall correctly, it has an interesting word phrase in it. Do you know what I'm speaking of? The word would be accept. And the phrase is accept as punishment for a crime. And I think as we consider constitutional legacies and even all the items that we talked about leading up to this point, that exception is one that's very important to consider as we think about the effects of our history and the effects of years and centuries of prejudice that accumulated over time. Is there anything else? I cut you off again. I'm so sorry.
No, that's because I just keep talking.
Well, I think you definitely see that exception in the immediate aftermath of the Reconstruction amendments. Then, you move into Jim Crow, where accept as punishment for crime. Well, who's determining what a crime is? So a crime could be loitering, for instance, and you see, people being arrested in jail for that, and you see a whole system of a prison labor for hire, which many call slavery by another name. So you always see, these little loopholes being used to exploit, again, now freed people and free people, but you still see the systems are hard to shake.
Yeah, I mean, that's the reason why we needed the 14th Amendment, is because after the 13th Amendment, the southern states enforced these black codes, which were like de facto slavery. Yeah. So breaking an employment contract was a crime. And so the 14th Amendment was ratified to give Congress the power to fight those black codes. And that's what I mean about the radical shift between the states and the federal government.
And then what happens with the 15th Amendment?
The 15th Amendment is all about voting rights, which of course, again, it looks great and it's a big accomplishment, but then it's years and decades of fighting to actually enforce the 15th Amendment. It's not till the Voting Rights Act, 60 years later.
Yes, progress is not quick, but finally, when we get to those amendments, we start seeing at least legislation and laws being put into place to try to make those changes possible in a way that we weren't seeing prior to that. Thank you. What does anyone want to speculate and share more about the legacy of slavery, of the Constitution?
I think it just goes to show that it can't be separated from this founding document and from the start of our country as a newly freed country, not colonies, under the British anymore. That it's entrenched, that no one is untouched by it. Even, if northern states were affected differently, they were still a part of it as well. And we just have to sit in that truth. Nothing is going to be gained by downplaying it, by denying it, by pretending that it's not there. We need to sit in that truth and recognize it and recognize what it was and what it is.
Right. I'm really even grateful that we're at a place now where we can sit and have this kind of conversation, honestly, about our history and about our past, and try to understand the laws, the Constitution, slavery, what's happening right now around us. Now, I'm getting towards the end of our evening, but I do want to ask, especially since this is the final event of our Constitution Weekend for this year, I wanted to ask if the Constitution didn't necessarily include everyone in the we the people, if everyone wasn't included as the people, then why celebrate the Constitution?
I think that's the most important question that we can ask ourselves. I personally think there's reason to celebrate, and I can get to that in a minute, but I agree with Hope that nobody is served by taking the Constitution out of context. Like, we have to appreciate it for what it was, which was a flawed document, a deeply flawed document that allowed people to own other people. And you can't separate that, you can't whitewash that out of the Constitution. Nobody's served by doing that. But if you think of the Constitution the way I described it earlier, as a mission statement, as laying out our values of equality, liberty, government by the people, freedom of expression, that is worth celebrating.
Yeah.
And that motivates every generation to fight for it, knowing that it wasn't perfect, knowing that it's still not perfect, but at least it's something that will inspire us all to be the better people who are worthy of the words written in that document.
Thank you. Thank you. I love that, because I just feel like, we shouldn't just celebrate something blindly without knowing why we're celebrating it. We have to examine it in order to appreciate it so that we can continue to aspire to it. Thank you.
I think about how we celebrate.
How?
Oftentimes, we mark a certain day, like September 17th was the actual day. And sometimes, you mark it, you see it on a calendar, but there's so much that goes on before you get to that moment. And then there's so much aftermath that happens later, and there's change. So I think this is an opportunity to go back to something that we probably all had in school, but hadn't thought about in a while. I mean, we deal in history every day, Deirdre, but like the Constitution, I was like in a 2-month crash course when you asked me to be on this panel, and just looking at what the Constitution says and what it doesn't, looking, at all the decisions that went into, certain parts. So I think this is an opportunity to look and to know, because nobody gains anything by being ignorant of, what this says. This is all, whether we're in it or not, whether it's explicit, whether it's good or bad, this is all a part of our history. And it's only going to be to our gain and to our benefit to know what it says, to know, what has changed, to know what people fought for to get, the Constitution amended and subsequent acts that had to be written to get basic protections that are in the Constitution, to be lived out. So we owe it to ourselves, our history, and the people that came before us to do that.
Thank you. That was really beautiful. I agree with both of you. And this, we've only looked at, again, our focus was slavery and the Constitution. And on this Constitution Day and henceforth, we can look at the Constitution in order to really appreciate something. You have to examine it, and you have to know what it says. And so the question that I pose to the audience that you can just think about as we wrap up this evening is, what do we do with our constitutional rights? And examine the Constitution so that you can know what those rights are. Now, we've only touched on a little bit. This is the tip of the iceberg regarding this conversation, and I'm so grateful for the opportunity to talk with you both and to be here, spaced out like we are. But there is more to be learned, and I know that I also had to do some deep diving and received a lot of help from a lot of people. But some of the sources that I came across that I really enjoyed and that were recommended to me, that I'll direct you to also, are James Madison's Montpelier's website. There is an article on slavery, the Constitution, and the lasting legacy. There's also a book that Hope recommended to me, Lawrence Goldstone's Dark Bargain, Slavery, Profits, and the Struggle for the Constitution. Perhaps you can take a class from Allie Larson here at William & Mary Law School. And one of my favorite books that I've enjoyed throughout my time at Colonial Williamsburg is Leon Higginbotham Jr.'s In the Matter of Color, Race and the American Legal Process. And those are just a few books. And I'm so grateful that we got to share with you, that we got to share with one another, and that we got to commemorate this Constitution Weekend, standing on the shoulders of so many ancestors and our new angel, Ruth Bader Ginsburg.
Ashe.
Thank you all so much for being with us, and thank you to everyone who supported this process. Have a great night.